Hey everyone, welcome to another edition of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, and not on Legal Friday, Alex Ooley of the Forge of Freedom podcast. Alex is an attorney in Indiana, although I'm going to combine the introduction with our usual disclaimer. Nothing he is about to say can be construed as legal advice. Alex, if you need legal advice, consult an attorney in your jurisdiction. Alex is here just for entertainment and education only. Alex, thanks for coming along for the ride today, man.
Yeah, great to be with you, Paul. It's weird not being with you on Friday, but happy to join in midweek.
Yeah, absolutely. We've got, and this is, of all the days to have you be able to be available, I'm glad today is the day. We have really a big story coming out of New Jersey, and good news for the most part coming out of New Jersey. I've got a press release from the SAF that I want to read off, and then we'll get a little bit into the details of Judge Bum's ruling here. A federal judge in New Jersey on Tuesday granted a preliminary injunction in part against certain tenets in the Garden State's revised gun permit law, Chapter 131, chalking up a win for the Second Amendment Foundation and its lawsuit partners. In her meticulously researched 235-page ruling, and open secret here, I haven't read 235 legalese pages in a couple hours. I just haven't been able to do that. Chief U.S. District Court Judge Renee Marie Bum writes, the Constitution leaves the states some measures to combat handgun violence, but what the Second Amendment prohibits is the states from doing, and what the state of New Jersey has done here with much of Chapter 131, is to prevent law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms. That is plainly unconstitutional. Bruin required the state bring its firearms laws in compliance with the Second Amendment, Judge Bum adds. Chapter 131 was the state's response, but it went too far, becoming the kind of law that Founding Father Thomas Jefferson would have warned against, since it disarms only those who are not inclined or determined to commit crimes and worsens the plight of the assaulted, but improves those of the assailants. I'm going to skip down here, and I'm going to go to Adam Kraut's quote. Adam Kraut, of course, the executive director of the SAF. Today's order granting our preliminary injunction against the state of New Jersey's anti-carry law confirms the rule of law is alive and well. After the Supreme Court decided Bruin last summer, the state of New Jersey enacted a series of restrictions that were wholly incompatible with the Constitution and disregarded the Supreme Court's directive. It's unfortunate that a lawsuit was required in order to force the state to respect its residents' constitutional right to bear arms. We will look forward to continuing to litigate these issues in New Jersey and across the nation to ensure constitutional rights are not meaningless words on paper. Alex, there is a whole list of places where she said that the state went too far and these cannot be prohibited places to carry.
Yeah, there's a bunch, and you're right to point out early in your commentary there that this is a 235-page opinion, and there was a lot of ground covered here. And Judge Bum, it's my understanding she was nominated by former President George Bush, so she's got presumably a conservative bent, and her commentary here in quoting Thomas Jefferson, that these laws would only serve to limit the law-abiding citizen and improve the situation of the criminal, because let's face it, all these laws would do is disarm the law-abiding, the good guy, and would make easier targets out of them for the bad guy. And that's the way it is with most gun control laws. So, and to your last point there are some good points from this opinion and some bad points. And Judge Bum goes through this laundry list of so-called sensitive places that the state prohibited people from carrying firearms. And there were a number of them that the judge ruled went too far. And this list, I think it's from, I think it's also in an article that you've put in the show notes from Cam Edwards at Bearing Arms. It includes places like zoos, parks, public libraries and museums, entertainment facilities, casinos, all sorts of places. And frankly, this law looks a lot like the Concealed Carry Improvement Act that we discussed on previous shows out of New York, where in response to the Bruin decision, the state had a laundry list of places effectively prohibiting the carry of firearms in public at all, because they included so many places in what they considered to be sensitive places.
Well, and New Jersey, I think, even topped New York, at least in one arena. They prohibited carry in vehicles, which made essentially the entire state a gun-free zone. Because let's face it, in today's society, it is rare for people to walk anywhere of consequence. People do some, jogging, bicycling, although bicycling, I think, could be construed as a vehicle. But people don't walk long distances anymore, and very little is within reasonable walking distance. So, yeah, with a law that says you can carry but not in your vehicle, it's really a law that says you can't carry.
Yeah, and I'm from the Midwest. I don't go to the East Coast a lot, but if you've ever been to the East Coast, you know that there is a lot of traffic. So even if there are people walking, nevertheless, this prohibition, like you said, would effectively prohibit the carry of firearms for a huge swath of the population, and effectively limits carry at all in public, because it's difficult to go somewhere without a vehicle.
Yeah, absolutely. I want to get a comment in here from C&T Designs and Arms. Why is that not coming? For some reason, I've lost my... It's going to look strange, but I'm going to go to a different one that I use on my Saturday show, but it'll get the comment in there. All these gun laws only serve as charges after the fact when a criminal uses a gun in a criminal act. These laws don't stop someone from committing a criminal act. That's pretty much spot on, Alex. What do you think?
Absolutely. I think, there's all this talk about common sense gun control and, compromising, reaching across the aisle. Well, I think the compromise needs to be, okay, which of the thousands of ineffective gun control laws can we repeal? Because they do nothing except to serve, to limit the law-abiding citizen. So I think that's a great point. A lot of times it's just a charge after the fact, after they've usually committed some other more egregious act, and the gun control law charge is of little or no consequence.
Yeah, absolutely. I also wanted to bring up in this one, and I want to scroll down here, one that's a thorn in my side, even in relatively free South Dakota. You're not allowed in New Jersey, and this was struck down, to carry in bars and restaurants that serve alcohol. I'm hoping that somehow this gets further down the road and it gets ruled that that's not, that you can't draw that distinction. In South Dakota, we have to know the books of the bar or restaurant we go to. And if they make 51% or more of their profit from alcohol, then we can't carry there. 50% or less, 49%, it's cool. All's good. There's no business owner in the world that's going to open their books to me, nor should they.
Right. Yeah. You can't walk into a place and be like, hey, what's your profits and losses? Where did you make your money last year? I mean, that's just effectively a ban on carrying in any place that serves alcohol, because there's no way you can get that information or know that information.
One other one that was in here, and this one, is often brought up as well. Medical offices and ambulatory care facilities. It does not specifically say hospitals here, but I'm all hospitals are in most of the in most of the United States. Hospitals are, if there are gun-free zones, hospitals are one of them, and that just makes them soft targets.
Yeah.
I'm hoping something can be done there as well. The other thing I wanted to bring up, this is just a preliminary injunction. This doesn't mean this case has been decided, and there's more arguments to come. There's a final ruling to come.
Yeah. Yeah, that's exactly right. And I think it's important for people to understand that a preliminary injunction is actually an extraordinary measure in a legal case. They're hard to get, yet we've been talking about them quite frequently after Bruin, because so many states have taken extreme measures to limit the right to keep and bear arms. And a preliminary injunction, the plaintiff, the person complaining about the law in this case, has to show that there's a reasonable probability of eventual success in the litigation. So that means they're likely to prevail on the merits once the case is fully litigated. The plaintiff has to show that they would be irreparably harmed if the law is not enjoined, is not put on pause. And they have to show that there's sort of this balance of harms, that there are other interested people, but their interests aren't as important or as immediate as my interest in exercising my right to keep and bear arms. And the judge here enjoined a great deal of this New Jersey law, saying that the plaintiff demonstrated all of these factors to obtain a preliminary injunction. So you're right, Paul, this case has not been decided, but the judge has said, and gives a good indication of the likely outcome, that the plaintiffs are likely to prevail once the case is fully litigated.
So, random legal question here. I suppose it could happen that Bum could, when this thing is finally decided, she could retract her preliminary injunction and rule on the side of New Jersey. That's not something that's disallowed, right?
Right, you're correct. She could, it's a good sign that she's entered this preliminary injunction, but once everything is fully litigated, it is possible that she could side with New Jersey with this law. I don't think it would be consistent with Bruin, but it is possible.
Sure.
And one thing I'd like to point out, too, we were talking about sensitive places and the laundry list that New Jersey prohibited. In Bruin, they touched on sensitive places a little bit, and it was actually a big point of discussion during oral argument in the Bruin case. And the court, in the opinion in Bruin, said that they really only identified 3 examples of sensitive places. I'm just going to read a little bit here. It says, although the historical record yields relatively few 18th and 19th century sensitive places where weapons were altogether prohibited, and these are the examples they give, e.g., legislative assemblies, polling places, and courthouses. So those are the only 3 examples that the court gives in its opinion in Bruin. So I'm not saying those are the only 3 places that would be upheld, but that's a very limited list of places, and I think places like New Jersey putting these laws into effect go far beyond what the historical tradition would support, which, as we know from Bruin, is what they have to comply with.
I'm going to get another comment in here from C&T Designs and Arms. Again, this is going to look a little different because I go to a Sunday or the weekend slide where there's 2 people normally sitting there. There's nobody there today, but we're going to pop this in there, and we've got the question is, so if someone is a designated driver, which I'm assuming is what DD meant, for the night, they cannot carry. It sure makes sense as long as I do not use my gun to unduly deprive someone else of life, liberty, or property. What else does it matter where I carry? And Alex, I'm going to say that that question, that's going to be a question for an attorney in your jurisdiction, simply because it varies so much state to state where you can and cannot carry. In South Dakota, the rule isn't that you cannot carry in the establishment that makes 51% of their profit from alcohol, unless you're the designated driver, that's not there. It's just you can't carry there.
Right, right. And I think there are a few other states that are like South Dakota, but you're right, Paul. You just need to really consult the law in your state and ask an attorney in your state if you have questions. I would point out that handgunlaw.us is a great resource for people to look that sort of information up. It at least points you to the law if you want to look up the original source, the original text.
It does, I've had Gary Slider, who runs that website on Polite Society podcast, a number of times. Not recently, but he's been there a number of times, and that website is updated weekly. When new laws come, they hit that website very quickly. So. If you're going to be going somewhere outside your local jurisdiction, for me, if I'm going outside of South Dakota, I refer to that for every state I'm going to be traveling through.
Yeah, I can't speak to other states, but I can tell you from my experience in Indiana, he does a great job keeping the digest of the law here up to date. And I think I noticed one mistake one time, which is why I always encourage people to look at the original source. But he does a great job keeping it up to date. At least it shows people where to look.
Yeah, absolutely. One other story I wanted to talk to you about, it's not in show notes, but I have been talking about it a little bit late last week and this week, and that was there was a ruling by a judge in the 4th District. This, I believe, was a Virginia. Yes, it was a Virginia case. Where the judge ruled, a federal judge ruled, that 18, 19, and 20-year-olds cannot be prohibited from purchasing handguns from FFLs. That goes way back to the Gun Control Act of 1968, where it ruled you had to be 21 to purchase a handgun from an FFL. Does this mean, and I'm really dropping this on you because I didn't give you much chance to research it, does this mean that 18, 19, and 20-year-olds in the 4th Circuit can now go to an FFL and buy a handgun?
Well, I haven't read that case, and I don't know what the status is, if that's being appealed, if there's been sort of stay of the decision pending appeal. I can't say for sure. But if the judge in that district made that ruling and there's no pending appeal, that would be my recollection. But again, before you would do that, I would try to get some confirmation from somebody in your jurisdiction. I'm not in the 4th Circuit. I don't know the status of that litigation off the top of my head. I didn't get a chance to look at that before I came on the air this evening. But yes, that is a possibility, if depending on the status of the litigation.
Well, and going back to that one, there's been a lot of litigation around 18, 19, and 20-year-olds. Specifically, the 5th Circuit did, in the carry restrictions, the 5th Circuit ruled that 18, 19, and 20-year-olds cannot be denied a concealed carry permit, and that one was not appealed. The state of Texas decided not to appeal that one. So I'm hopeful that this 4th Circuit and the 5th Circuit ruling do, although they're not opposing rulings, so this wouldn't get before the Supreme Court. I hope that the momentum here at least does move forward for people between 18 and 20-year-olds to get all of their Second Amendment rights.
Right, and the thing you're pointing to there, when you mentioned that these are not opposed rulings, these are rulings that are consistent, is a circuit split, right? And we're likely to have, if we don't already have, I don't know off the top of my head, another circuit that disagrees with this ruling has issued an opinion about this restriction on the ability of 18 to 20-year-olds to purchase firearms. So if there is another circuit that has a ruling that's inconsistent with the 5th or the 4th Circuit, then the Supreme Court is more likely to take up that issue to resolve that conflict between the circuit courts.
Let me get a comment in here from 500 Magnum. He says, They're trying to pass some BS so-called safe storage laws, safe for criminals, that is, here in Georgia, but I guess they didn't have the votes. Haven't heard any more about that, thank God. So I do know in politics news, specifically about Tennessee, there actually, I do not know if that made it into what I had for sure. Yeah, Memphis. I'm going to go to this one. Memphis leaders are looking to address gun violence by proposing new laws which would restrict access to certain weapons. Councilman J.B. Smiley is sponsoring an ordinance that would ban permitless carry, assault rifles, and the ability to store weapons in your vehicle unless it's in a lockbox. There is a proliferation of firearms in the city. If state elected officials are derelict in their duty, refusing to take care of our people on the local level, we have an obligation to make sure they are safe in their homes and their communities, and that's what this ordinance is about, Smiley said. And I'm just going to cut to the chase here. Tennessee does have a preemption law, meaning that cities, counties, local jurisdictions cannot pass laws tougher than state laws. And I think Memphis is about to find that out, and I hope it's going to cost them a good deal of currency.
Yeah, in Indiana and in other jurisdictions, I know that if a locality violates state law and violates preemption, that attorneys can request attorney's fees, and so that there's some teeth behind violating state law. So hopefully that's the case in Tennessee. I don't know for sure what the law is there in Tennessee, but I suspect there is some sort of provision about attorney's fees down there for that sort of tactic to hold the localities accountable. But like we talked about in other situations before, it's ultimately the taxpayers that bear the burden of rogue local governments like this.
Well, and this is something I think you're uniquely positioned to speak to. Attorney's fees does not include all the costs of bringing litigation. Attorney's fees is a part of it, but there's also filing fees, there's documentation fees. You know, that to get a case before the Supreme Court, I was told takes $1 million to get it there, talking about the U.S. Supreme Court, and then it multiplies by at least 5 times to get it through the Supreme Court. Attorney's fees are part of it, but not all of it.
Right. There are huge expenses associated with litigation that don't involve attorney fees at all. It could be expert witnesses, it could be research, it could be staff and assistants. I mean, there's all sorts of things that go into bringing a case, especially to the Supreme Court. But even at a lower level, in local courts and county courts and state courts, litigation is still very expensive. So while it does provide some incentive, attorney's fees does not recompense the plaintiff for all of their losses.
Yeah, and that's I'm going to turn this into a little bit of a pitch for being a member of SAF, simply because, yeah, the SAF does occasionally get judgments where we get attorney's fees compensated for. We also have attorneys that work for free, so sometimes, all the time, if we get an award, it doesn't cover all the costs of the litigation. These lawsuits are not and can never be free. Your being a member of SAF helps greatly. If you're not a lifetime member, please consider joining at saf.org/join. Let's see here.
And Paul, I'd like to talk about a couple other things from this New Jersey case, if that's okay. I think that I didn't, like you, I didn't get to read the whole opinion, but I did get through as much of it as I could. And there were a couple other issues. There was an insurance mandate that was being challenged as part of this lawsuit, and the court enjoined the insurance requirement. So there was a requirement that if you wanted to carry a firearm for self-defense, you had to maintain insurance. And remember, it's important to point out here that and we know this from Heller and from Bruin more explicitly, that the standard for applying the Second Amendment is as follows. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct, and the government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition. And so here, the court, in analyzing the insurance mandate in New Jersey, found that this insurance mandate did, in fact, implicate and burden the rights of people to keep and bear arms, because you can't keep and bear arms unless you have insurance. So it is a burden on the right. And the state or the court here enjoined that provision. So I thought that was good news and a good sign. The other thing that the court looked at was this default rule about whether someone could carry a firearm on private property. And this is an interesting distinction the court made. So the court says the plain text of the Second Amendment covers this prohibition. However, carrying firearms for self-defense on private lands that are held open to the public is conduct that is presumptively protected by the Constitution. So this default rule in New Jersey, this law in New Jersey that prohibited the carry of firearms on private property unless the private property gave you permission or had a sign up, violates the Second Amendment according to this court, if it's private property that's held open to the public. However, if it's private property that's not held open to the public, then it does not violate the Second Amendment. And you're on mute, I think, there, Paul. You're on mute.
Thank you.
Yeah.
The private property open to the public, we're talking grocery stores, we're talking barber shops, place where the general public can walk right in. That's
Right.
not open to the public, you're talking about somebody's private home.
Right. And that's an interesting distinction. This is the first time I've seen that distinction made in a court opinion. And I think it makes some sense because it sort of balances the right to keep and bear arms with the right of the private property owner. I think if I don't like the default rule, but I don't think that homeowners, the default should be that people can't carry into a home unless the person gives them permission. I would rather the default be that they have to be denied permission to carry. But nevertheless, I thought this was an interesting distinction to point out.
Yeah, absolutely. And I'm going to tell you this, if you come into the Lathrop household, you'd probably be uncomfortable if you weren't carrying because everybody else here is. So we are coming down to the bottom of the hour. I knew this would take up most of our time. Alex, on our way out the door, if you would, please, man, tell us about Forge of Freedom podcast and anything else you want to plug, man.
Yeah, so obviously I care a lot about firearms and the right to keep and bear arms, but my passion doesn't end there. I care more broadly about freedom, and I decided to start a podcast that's available on YouTube, Rumble, and all the most popular podcast streaming platforms. It's called The Forge of Freedom, and talk about all things related to freedom. I started doing, it's a weekly episode that's released on Sunday, but I also started releasing an episode every Monday. We call it Monday Gun Day. It's probably not original. I'm sure somebody else uses that, but it's a way for listeners to remember that we release a firearms-related topic on Monday. And a lot of times that's with my father, who's also an attorney and a firearms instructor. Most recently, we released an episode about the ATF final rule on the pistol brace situation and talked about what your options were and what the likelihood of some change is going forward. So if that's something that might be of interest to you, check it out. It's Forge of Freedom.
Absolutely. And for those who are longtime consumers of the bullet, they know that Legal Friday started out with not just Alex, but it was Alex and Mike. They both joined in. And Mike's got a busy schedule, and so Alex just kind of took over. So All right, that's going to do it for us tonight. Everybody, thank you for watching. Thanks, podcast listeners, for listening. Please do come join us again tomorrow, 6 p.m. Central Time, for another edition of The Bullet. Thank you, everybody. We'll see you next time.